seated. Good morning, Council. You may notice we're not wearing masks, nor most of the people in the courtroom, and that is because we're all vaccinated. If you are vaccinated, you can remove your mask if you choose to. But if you're not vaccinated, keep your mask on. All right, Mr. Alexander, we're up next with State versus German. Are you prepared to go forward, sir?
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. May it please the Court. I want to begin by suggesting a framework for analysis for this Court. There are two different constitutional provisions here at issue, the Fourth Amendment and the South Carolina Constitution's right of privacy. At some point during this process, the state has raised various exceptions to the warrant requirement. There may be inflection points where those two analyses can diverge, and this Court will have an opportunity to take a stand to protect South Carolinians' rights to privacy. In that respect, I would liken it to this Court's decision in the Key case, probably its most recent decision dealing with these kinds of blood draws, where this Court noted a flaw in the U.S. Supreme Court's opinion, saying that the burden was on the defendant for these types of analyses, of course, incorrect. So the first part of the analysis is the implied consent. Is it unconstitutional? And here we're dealing with felony DUI. Felony DUI statute says that when you're charged with that, you have no choice but to give your blood. That pulls this case directly under McNeely and Birchfield, both of which were decided before the blood draw at issue in this case. So the implied consent statute is, as applied, unconstitutional in this case because it provides no alternative, but the state is going to forcibly.
And we should look at that standing alone, should we not, Mr. Alexander, separate and apart from any exigency because of the way this case was tried and because they are two separate arguably exceptions to the warrant requirements.
I think this Court should look at that because one of the main reasons is the state keeps falling back on a good faith exception in these cases. And I think this Court, telling the world what we all know after McNeely and Birchfield, that a warrant is required, would go a long way towards remedying any final questions about good faith.
But the Prado case, I believe it's a Wisconsin case, I'm sure you're familiar with, State v. Prado. In that case, the Court held that the statute was unconstitutional, but upheld the good faith determination. Why is it good faith that the officer was relying on the statute, albeit the wrong one? But why wasn't that? Why isn't that something we should consider?
I mean, I think certainly after Birchfield, because there's three cases in Birchfield, Your Honor, and one of them I think is the Bayland decision that's part of those three cases. The North Dakota statute said you had to consent under pain of a criminal penalty. If you didn't consent, that's a separate crime. And the Court said that is unconstitutional. That kind of consent is not true consent. But here we have something that's even worse than that. You don't have a choice at all. You have no consent under the felony DUI statute. The state just holds you down and takes your blood. So I think at that point...
Why are you so quick to read the statute that way? Why can't we read the word must and the requirement under 2946A in combination with the concept of implied consent that is in 56.5.2950? So that if you start off by reading 2950 to say that if you choose to drive in South Carolina, you consent to have your blood tested, and then you get over to 2946A, and then you say, well, if there's a probable cause of a felony DUI, then because you have consented impliedly under 2950, you must give a blood test. So the must plays off of 2950. Which means that it absolutely doesn't require an absolute blood test, because if you revoke your consent under 2950, then you no longer have to give the blood test.
Well, perhaps the Court need not reach this question because Ms. German certainly revoked her
Well, maybe, but that would be the next question. But on the question that I asked, why is that not a, and in fact, as you certainly know, we are required to read these statutes consistent with the Constitution if we can. So if we read these two statutes in conjunction, and the must simply is a derivative of implied consent, why is that not valid?
The must is a mandatory term, Your Honor. Even if you read it in conjunction with that, a false choice of implied consent in Birchfield under pain of a criminal penalty.
Yeah, but Birchfield's totally different because this is not under pain of criminal penalty. That is not what we're dealing with here.
So, I mean, I think the idea that no choice at all.
Birchfield, in fact, specifically tells us that there is no reason to read Birchfield as casting doubt on the general concept of implied consent.
That's correct, Your Honor. And if you look at one of those cases, the defendant only faced, I think, a civil penalty for refusing.
My question is very narrow. Why is it not possible, if not required, that we read the word must in 2946A as derivative of implied consent under 2950, so that if there is consent under 2950, you must give a blood test. If there is not consent, or if the consent has been revoked, then you don't have to give a blood test.
I disagree with that analysis here. I mean, the way it's been interpreted here is they're taking your blood, and that is more intrusive in South Carolina, I think, than a choice of facing a smaller criminal penalty. I think Birchfield, respectfully, Your Honor, does decide this issue.
Mr. Alexander, if I could take you back to Justice Hearn's question about the good faith exception. Birchfield was decided on June the 23rd of 2016. This trooper was dealing with this individual early morning hours, 2, 3, 4 o'clock on July the 10th of 2016. So a 3 weeks after Birchfield, and we can tell from this prior dialogue, we don't know what the extent of Birchfield is. And fast forward to 2020 and our decision in McCall. We recognize momentum in this area and the case law moving in a particular way. That's the way constitutional issues generally evolve over time. And even with that opportunity, we didn't strike the statute down. The statute still stood. So why couldn't they, and it has to be clearly unconstitutional to have good faith not available. So how do we assign to this trooper bad faith, lack of good faith on July 10th, 2016, that this was clearly as a bail unconstitutional, when 4 years later this court couldn't even come to a conclusion and find it unconstitutional? So why wouldn't good faith apply?
Well, Your Honor, I think there's several problems there. The first would be, where would you draw the line? I think once the Supreme Court decides that case, we get the benefit of it. The second part is that even Davis' good faith, as expansive as it is, doesn't say that police officers have to wait on this court to tell them what the United States Supreme Court has said. The binding appellate precedent under Davis are decisions of the U.S. Supreme Court and decisions of our courts here, this court and the Court of Appeals. So that decision from the U.S. Supreme Court, when it came down 3 weeks before this accident, was binding on these officers. So good faith just does not apply. You can't give a grace period under which to violate citizens' Fourth Amendment rights.
If I may follow up, what about what I just read to you out of Birchfield, which says that our prior opinions have referred approvingly to the general concept of implied consent, and nothing in this opinion should be read to cast doubt on that.
This quote is, petitioners do not question the constitutionality of those laws, and nothing we say here should be read to cast doubt on them.
Well, but then the following sentence says, it is another matter, however, for the state not only to insist upon an intrusive blood test, but also to impose criminal penalties, although that's not the situation here. I think the focus there was about the breath test, saying that's all right, don't cast doubt on it. I don't see, we'll let you argue your case, but,
I mean, you just heard the three of us express at least two different opinions about how to reach Birchfield. How in the world are we to, this is following up on Justice Kittredge, how are we in the world to expect this officer to fully understand it?
They have to understand there's no other clear way to do it, Your Honor. You can't have officers not be bound by the United States Supreme Court.
So the Wisconsin Supreme Court, I'm getting back to State v. Prada, that was just issued on June 21st of this year, clearly after Birchfield, and they held that good faith was viable. So your response as to why good faith isn't viable is because this was 3 weeks? This officer's actions were taken 3 weeks after?
I mean, my answer would be the same if it was 5 hours after the incident. The only time you can draw the line is when the case is decided. You get the benefit of the law after the case is decided. As far as the statutory scheme in striking down implied consent, my reading of Birchfield as a whole is it goes through a large analysis about implied consent laws. It talks about breath tests and the level of intrusion. It talks about blood tests and the level of intrusion. It harkens back to Schmerber. It goes through McNeely. But the impact of the court did not want to say all of these implied consent laws are out the window. They balanced the intrusion with the need for it.
What's the biggest intrusion under our DUI laws?
I think holding someone down and taking their blood, like was done to Ms. German, would be right up there, Your Honor.
Let me ask you this question. The defense of necessity. First of all, it's not an issue in this case. Does the defendant have the burden of proving that as charged by the trial court?
Yes, Your Honor.
So the state doesn't have to disprove it?
It's the defendant's burden by preponderance, and the defense of necessity is in this case. She received a necessity.
I was just curious. You don't see many charges on a burden that the defendant has. My bigger question was intoxication conceded by the defendant when that charge was requested and that defense was pushed at trial?
She concedes that she had been drinking.
4 vodka drinks and a beer?
Yes, Your Honor.
And other witnesses said she was hammered?
They said she was intoxicated, Your Honor. I mean, this is, I assume you're going towards harmless error here, Your Honor.
Yeah.
My argument on that is twofold. Number one, the blood alcohol level in this case is staggering. It's 0.275.
And it's just too much for the jury to overlook that number.
That's the first part, yes, Your Honor. The second part...
Now, go ahead. I want you to finish the second part.
The second part, Your Honor, is hearing that number certainly affects their determination of Ms. German's perceptions that night.
At most, all it's going to do is say, yeah, I'm right, she was drunk. I mean, you had all this evidence in this case, there's quite a bit of it, that she was hammered. More than one witness testified that I believe 2 witnesses, if my memory serves me correctly, say she was hammered. 4 vodka drinks and a beer.
But yes, Your Honor, but if she prevails on the defense of necessity, which was really her only defense here.
But she didn't prevail on that.
Because they heard this illegally obtained evidence, the 0.275, Your Honor.
Well,
once they heard that.
That's debatable.
But doesn't the defense of necessity, in effect, concede that a crime was committed, but there was a reason for the crime to be committed?
That's the boilerplate language.
So why wouldn't we consider that in the harmless error analysis, if we get to that point?
I'm not telling the court they can't consider that. Of course you are. What I am telling the court is that number, that 0.275, is so huge that when the jury hears that, anything Ms. German says about what she remembers that night and her testimony about that night, and also her husband, because her husband's there drinking with her and he's the other witness, they're likely to assume he's just as drunk as she is.
So how about 0.08, 0.09, 0.18? So you just know 0.275 is just too much.
That's way, way past anything that could be harmless error.
What about striking other cars in the parking lot, running the stop sign?
Well, Your Honor, again, that falls under the defense of necessity. Under Ms. German's testimony, her husband's testimony, they were being attacked by an angry mob. They had a gun pulled on them. They had nothing they could do but try to escape there. If the jury believes them, which they would have been more inclined to do.
She didn't remember the gun until it was convenient for her to do so, isn't that right?
Well, what Ms. German said was that the hospital had given her Haldol, which is all backed up by the medical records, and she was still fuzzy from that time. And her testimony is that she remembered the gun. I mean, juries hear conflicting witness statements all the time come from the state when they have co-defendants on the stand. And they believe them and convict defendants all the time.
Mr. Alexander, you started out by saying that you were going to give us a framework for analysis in this case, and you started talking about the constitutional aspect of this case, and I assume two separate claims. Did you finish that? If you did, I didn't understand it.
Yes, Your Honor. There may be points as you consider this. For example, the state's probably going to make an exigent circumstances argument here in a few minutes. That says, the burden is to show that the probative value of the evidence might decline. That might be the Fourth Amendment analysis. But this court could say, when it's practicable under the South Carolina Constitution, you should get a warrant. So at those points, Your Honor, I would say this court has an opportunity in this case to address the South Carolina Constitution's impact on this statute, which it hasn't had a chance to do yet. And those points where it could differ are places where I would urge this court to adopt a ruling and rules that protect our citizens' right to privacy.
Now, are you saying the consideration of the South Carolina Constitution, the privacy provision, is your second prong of your analysis, or what are you saying?
Right, you're right. The case below was argued mostly under the Fourth Amendment, and I think we win under the Fourth Amendment. But the key case, this court sent it back for a remand. And I think there are several points here under the South Carolina Constitution where you can say no remand is necessary. For example, the exigent circumstances.
Well, if we did a remand, that would be like giving the state a do-over on exigent circumstances when they specifically stated they were not riding that horse.
That's correct, Your Honor, and that's the waiver argument that we have in our brief, and I'm happy to address that.
Can I ask one more?
Yes, go ahead.
Is what was said by the solicitor in this case about exigent circumstances materially different than what was said in the Key case?
My understanding from watching the argument in the Key case was the solicitor said, in that case, we don't need to get to.
That's different than saying this isn't about exigent circumstances.
Correct,
We
Your
don't
Honor.
need to get to it. It's there, but we don't need to reach it. But in this case, the solicitor said very clearly, this case is not about exigent circumstances.
This case is a strategic waiver by the solicitor to try to get around McNeely. And I think the court should hold them to that. Thank you, Your Honor.
Thank you very much. Mr. Edwards.
May it please the court?
Yes, sir.
My name is Josh Edwards, and I represent the state in this case. I'll start off with the good faith exception because that's what the trial court based its ruling on. So before we get to any additional sustaining grounds that there might be issues with, I think this case fits squarely within the good faith exception. Your Honor, Auto case.
Well, I have to correct myself. I got excited about Prada because it was just decided this year, but actually the conduct, the arrest, was back in 2014, which was pre-Birchfield or McNeely. So I don't know if that was a valid point. So what I'm saying, perhaps Mr. Alexander is correct, that as soon as the decision comes down, we should hold the state to that decision.
Yes, Your Honor, but I don't think Birchfield precludes the good faith exception in this case. Birchfield was an as-applied challenge to a much different statute. The North Dakota statute provided for warrantless blood draws in all DUI cases. This is not a DUI case. This is a felony DUI case.
How does that make a difference?
Because it's a completely different category of offense, Your Honor, because the balancing of interest is totally different. In a misdemeanor DUI, 30-day offense, you have a justification based on deterrence.
But what about Justice Alito's comments in Birchfield that says even if there's an injury, the law enforcement officer has an opportunity to request a warrant?
Well, I think I know the part.
Even if the injury prevents a breath test, he says the officer has an opportunity to request a warrant. So maybe I'm missing something.
I think that section of Birchfield, he's talking about misdemeanor DUIs.
He doesn't say that, does he?
Well, he says that we have no reason to believe that injury or hospital trips are common in DUI drunk driving cases. They're absolutely common in felony DUI cases. The overwhelming majority of these cases involve a catastrophic accident where everybody's going to the hospital. And so I think that statement in Birchfield, the drunk driving cases, that can be limited to its.
But he says, well, you said part of what he says. He says, we have no reason to believe that such situations, he's talking about serious injury, are common in drunk driving arrests, and when they arise, meaning serious injury, the police may apply for a warrant if need be. He doesn't say you don't have to do that because it's misdemeanor.
I think, based on the context of the case and the language he uses, that statement should be limited to misdemeanor DUIs.
I don't get that argument. That makes no sense to me, because we're talking about the constitutional question of whether it violates the Fourth Amendment to go in and draw this blood without a warrant. And I don't think that the severity of the crime affects the suspect's constitutional rights under the Fourth Amendment.
I think it does, Your Honor, because it's a balancing of interests, and especially the search incident to arrest exception.
So the search, so you contend that the parameters of a legitimate search incident to an arrest are dependent on the seriousness of the crime for which the person is arrested.
Yes, Your Honor.
Wait a minute, now let's go back to Birchfield again, if that's your position. Justice Alito specifically says that it's not allowed what it says, let me read the whole thing instead of trying to shorten it. Because breath tests are significantly less intrusive than blood tests, and in most cases amply serve law enforcement interests, we conclude that a breath test, but not a blood test, may be administered as a search incident to a lawful arrest. Does he not say that?
In the run-of-the-mill DUI case. Yes,
No, that's not what he says. That's what you want us to.
That's what I want you to interpret
Okay.
the case to say.
All right.
And I will be completely candid. I'm asking for this court to carve out a small exception, search incident to arrest exception, that applies only in felony DUI cases.
So do you have any precedent to cite to us to support this notion?
Well, I will cite to Mitchell. I will cite to Terry versus Ohio. I will cite to Birchfield, because in those cases, the court considered the circumstances.
I mean, on the narrow point that the parameters of a legitimate search incident to an arrest, as an exception to the Fourth Amendment warrant requirement, vary. Those parameters vary depending on the perceived seriousness of the crime.
Yes, Your Honor, because it's a balancing test.
Wait, no. The question is, do you have any citations to give us?
Not that are online exactly with the facts of this case, no, sir. But
So we're just going to make this up.
no, I think you can look to these other cases that I've referred to and accept the fact that the Supreme Court bases constitutional rules on the specific facts of specific cases, taking into account all of these circumstances.
Why wasn't exigent circumstances developed in front of the trial court?
I have a theory. I think the theory is because the trooper said that, I didn't rely on exigent circumstances. The trooper said I took the blood because the statute says I can, and I think that's what the solicitor was trying to say when he made that statement.
So what was the exigent circumstances exception waived?
No, Your Honor.
Why not? When he specifically said he was not, he asking for the blood draw for that reason.
Well, I think he was.
And matter of fact, the lower court found that to be the case. Is that not right?
I don't think the lower court ruled on exigent circumstances at all.
Well, I know what he ruled on was the reason for the blood draw, and that he was not dependent upon exigent circumstances. Is that correct?
Yes, Your Honor. I think the trooper.
So if he waived it, then how are we to consider it at this juncture?
Well, I think the state won on the argument that it made. If the state would have lost that argument, I think it probably would have moved
Well, you
on.
didn't make the argument. You may have waived it, but that in no manner prevents this court under Rule 220 for affirming on any ground appearing in the record.
Yes, Your
The
Honor.
problem is the phrase appearing in the record, because not only did the state not advance an argument for exigency, and there may have been plenty because the ER doctor testified as to the belligerent, uncooperative nature of the defendant. She tried to bite and spit on the nurses, yelling, cussing, et cetera, until they finally had to administer during her 6-hour stay sedation on 2 different occasions. But that was never advanced. That lulls the defendant in not responding. So our authority under 220 is limited to what appears in the record. I question whether it appears in the record. I'm not so much concerned about the state weighing it, Because I think the court has the authority to affirm under 220C if it appears in the record.
Yes, Your Honor, I understand.
How do I overcome the fact it does not appear in the record?
Well, I think the facts do appear in the record. And the most important fact of all, aside from the fact that alcohol always creates a degree of exigency because it dissipates in your blood, is the fact that Ms. German went to the hospital before these troopers even got on the scene. So it's
Well, but what about, now, we're talking about affirming on any grounds appearing in the record, but that's not absolute, is it?
It's within the discretion of this court, Your Honor.
Within the discretion of the court. And when you go back to Ion says the court is unlikely to do so where it would appear unfair, unavailable, or unwise to do so. Now, would it not be unfair if you waived it, and as Justice Kittredge has indicated, you lulled the defense into not defending on that position? How would it be fair for you to then come back to this court and try to argue it, say it's in the record?
Well, Your Honor, the defense made a lengthy argument on exigent circumstances, and the circuit court listened to that argument, considered the argument, and he chose to go with the state's argument instead. And so it's true the state did not advance the argument, but the defense did, and the facts are in the record. This is a quintessential exigent circumstances case. You have a catastrophic accident, you have a chaotic scene, as Mr. Alexander pointed out, it's called the Grown and Sexy Bash. You had $10 unlimited liquor drinks all night. There were crowds of people hanging out in the parking lot right next to the road. She's injured in this accident. She hits her head on the windshield so hard she shatters the windshield, and she's taken into
So
hospital.
your position is that when we say we might affirm on anything appearing in the record, long as the factual situation includes it,
Yes, Your
it does not have to be, whatever reason, pursued by the party who wants to take advantage of it.
Yes, Your Honor, just like in the Key case. And the language is slightly different, but I think
You don't even have to raise it. You don't have to do anything. It's just a factual.
if the facts are in the record, yes, Your Honor, this court can consider it. And if the facts weren't so strong in this case and so clear in this case, then I might not have made that argument. But I think the facts of this case clearly show exigent circumstances. Most importantly, the trip to the hospital. Got a major head injury. Well, they could have believed reasonably she had a major head injury based on looking at the windshield. They don't know if she's going to be in surgery by the time they get there. They don't know what drugs are being administered at the hospital. This is the major fact. She's taken to the hospital. They don't know if they're ever going to have the opportunity to do a blood draw at all.
Speak to us about the good faith exception,
Yes, Your Honor.
that this officer in the middle of the night on July 10th, 2016 should have been well versed in Birchfield, even though we can't even agree up here what it means and the extent of it. And this court 2 years ago didn't strike down the statute. So in that context, speak to us about the good faith exception.
That's exactly right, Your Honor. We have a very complicated statutory scheme in South Carolina for DUI investigations. And as we just saw in the last case that was argued here, it's hard to investigate a DUI correctly and follow all the rules that are set out in the statute. And so when these officers are trained, that's why Highway Patrol does almost all DUI investigations, because they are trained to follow the statute step by step. And if you step out of line, this case is probably going to get dismissed at the circuit court level. And so the statute is valid, the statute is good. Birchfield and McNeely did not invalidate it. This court, as you noted, has had chances to invalidate it and has not.
Well, help me with this language in Birchfield. Having concluded that the search incident to arrest doctrine does not justify the warrantless taking of a blood sample, what does that mean? If it's court specifically says you can't do it, so why is that confusing?
Again, I would ask this court to interpret that language to apply to misdemeanor 30-day DUI cases. And the reason I'm advancing the search incident to arrest exception is, let's call it what it is. 2946 comes into effect upon arrest for a felony DUI. This is not, and this argument is sort of a policy argument, but this is not a situation where you're going to have the danger of arbitrary enforcement over aggressive police officers at a checkpoint or a traffic stop, where they're relying basically on information that the judge is not in a place to dispute. This rule.
So
that
let
I'm
me ask you
proposing-
this then. Any constitutional challenge to that section then must be as applied.
And it
as
is
opposed
as
to
applied in
facial.
this case, Your Honor.
Now, as applied is the argument being made by Ms. German, is that not correct?
Yes, Your Honor.
The one thing that I can't fathom is why neither in your brief nor here at this argument you have argued that the implied consent statute justifies this search.
Well, that's what I'm arguing. Basically, it's a statutorily created search incident to arrest exception.
Search incident to arrest is not the same thing as consent. Those are different exceptions to the warrant requirement.
I agree.
And when the legislature enacted 56-5-2950, they were not concerned with a search incident to arrest. They were concerned with the consent exception to the warrant requirement. You have, do you, and you just got finished saying that you, that we have a complicated statute, and we've all acknowledged that in McCall and in other, in McCall, we did not invalidate the implied consent argument, the application to felony DUI. Do you contend that the implied consent law justifies this blood search, blood draw?
Yes.
All right.
It is, calling it what it is a statutorily, legislatively created statute that provides.
So you think the statute is still constitutional?
Yes, Your Honor.
We've come a long way in 10 years, from McNeely all the way through other cases. And even though we have question marks about Birchfield, you still think our statute that creates a categorical rule that anyone arrested for felony to DUI doesn't have a Fourth Amendment right, and they must give blood, and there's no defense to it?
Well, they have a Fourth Amendment right that it be done with probable cause, and they can always contest that after the fact.
What about the South Carolina constitutional right?
I don't think that changes anything.
Why not?
Well, because it speaks specifically to a right of privacy.
Well, blood draw has nothing to do with right to privacy?
This is not a privacy concern, Your Honor. She's in the hospital. She's given blood already.
But not to the police.
That's true. And so it's
Not to the government.
That's true. And so, but that, to me, that doesn't really implicate a privacy interest when the only reason they're taking this blood that you've already given is so we'll have an accurate test that's done by SLED.
No, they weren't taking that blood because it was already given. They demanded the blood draw.
Yes, Your Honor. And they didn't take it because it was already given. They took it because the statute says that that's what they're supposed to do.
I want to ask you a follow-up question to what Justice Kittredge just asked you. Under the concept of consent, under the concept of implied consent, if in fact there is a categorical rule that your client must give a blood sample upon the determination of probable cause for felony DUI, I'm sorry, but you're going to lose on consent.
Well, I'm not making a consent argument, Your Honor. I'm making a search argument.
You are making a consent argument.
Wait. I just asked you a lengthy question 3 minutes ago as to whether you were arguing consent is valid, and you told me yes, and now you're telling me no.
You asked me if the implied consent statute is valid, and it is. It's just not. That's a legal fiction. Implied consent is a legal fiction. What it really is a search incident to arrest.
That is absolute nonsense. Those are completely separate exceptions to the warrant requirement. The South Carolina legislature, for all of its plenary powers that we recognize here from this bench and in our opinions on a regular basis, does not have the power to statutorily expand the search incident to arrest exception to the warrant requirement. With all due respect to our friends across the street, they don't have that power.
I think they do, Your Honor. And just to clarify what I said about consent, implied consent and consent are two different things. And when we argued State versus Key,
But with the same result. So tell us why it's a distinction without a difference.
well, this is just a matter of terminology, exactly.
Well, I want to ask you a question because you have told us that you do not believe that the implied consent concept embodied in our statutes here is invalid for purposes of felony DUI. But do you contend that this particular blood draw can be sustained to a Fourth Amendment challenge under the consent exception to the warrant requirement? Yes or no?
An exception to the warrant requirement.
Yes.
For federal constitutional law. No.
No, you don't make that contention.
No, Your Honor.
Not only did he say it didn't make that contention, he said you can't do it. if I understood your response.
Well, I'm not going there because we don't need to go there.
You don't think that there's a consent exception to the warrant requirement?
There actually is an affirmative consent exception in all the cases that this court cited.
You don't think there's an implied consent?
Implied consent to the federal constitution?
So you're just saying
Wait a minute now.
implied consent does not equal consent exception to the
This court
warrant
noted
requirement.
in
But isn't that all you've got here? Because she specifically did not consent. We know that. This isn't like an unconscious person.
Yes,
Many of the states
That's
deal
implied
with
consent.
that.
yes.
So she did not consent. So really, all you've got to rely on, isn't it, is the implied consent statute.
The implied consent statute, when applied to federal constitutional law, in actuality, is a search incident to arrest. If we're talking in constitutional terms, it's a search incident to arrest. It's what it is.
I could not disagree with you more fundamentally about that.
But we had fun talking about it. I will say, number one, this is an accident or circumstances case. Number two, the good faith exception applies. Number three, it's harmless error. Number four, this court should consider the search incident to arrest rule because it's a good rule in this very small category of case.
All right, we have one question from Justice Kittredge.
I understand all your arguments, but where I've completely lost is the idea that the statute somehow remains constitutional because it has the imprimatur of the legislative branch. I don't understand that. Okay, respond to that, and then I'm going to...
That shows that society deems it reasonable under the Fourth Amendment,
All right,
to conduct a blood draw in this very small category of case, felony DUI.
okay, the
that's
legislature deems it
And this court
proper,
should consider that.
and we should consider that.
Yes, Your Honor.
In our form of government, the judicial branch determines the constitutionality of a statute.
Absolutely,
And when they're in conflict,
which they're not in this case.
you don't think this statute that says when you're arrested for felony DUI, you must give the breath, the urine, and the blood sample. You don't think that's in conflict with the Constitution?
No, Your Honor.
All right, in 2013, I know it only began as a plurality, but these things take time. There's a process. In this plurality, Justice Sotomayor in McNeely talked about the Fourth Amendment does not tolerate a broad categorical approach. Talks about diminished expectations of motorists, implied consent laws. But the motorist's diminished expectation of privacy does not diminish their privacy interest in preventing a government agent from piercing their skin. Any compelled intrusion into the human body implicates significant constitutionally protected privacy interest. Well, that plurality has grown. We may have a difference on what Birchfield meant, but we come to Mitchell, we come McCall where we didn't end it, but we are here today. And given what the Constitution says, you still want the legislature to trump the Constitution.
They're not trumping the Constitution, Your Honor. The law is consistent with the Constitution.
So you
It's a
think
balancing of the interests.
a state law that makes a categorical approach
For this very small category of cases.
for felony DUIs
Yes.
is constitutionally permissible?
Yes, Your Honor. The United States Supreme Court has never considered a felony DUI case. I think they would decide it differently than they did Birchfield.
I disagree.
Now, when you say that in response to Justice Kittredge's question, I want to make sure I understand. You're arguing to him not the idea of consent. You're arguing to him the idea that this is a legitimate search incident to an arrest.
Yes. When they say implied consent, what they really mean is search incident to arrest. And if you read the words of the statute, triggered upon arrest for felony DUI. That's what it is. It's reasonable under the Fourth Amendment.
Well, then I'll leave it alone, but Birchfield really kicks you out of court if that's your position.
I need this court to limit Birchfield to its facts.
I tried that in Key, but all All right.
All right, thank you very much.
Thank you.
Mr. Alexander. Talk to us, well, a little bit, please, sir, about the South Carolina Constitution. Mr. Edwards kind of glossed over the application by saying it's not applicable, it's the same. Tell me why it's different.
Well, we know it's different because this court has said it's different.
All this court has really
Counsel
said, without really expounded on it, is just saying that more protection is provided by the South Carolina Constitution than the federal Constitution. Federal Constitution is just the floor, not the ceiling. But he says this is not a privacy situation.
I think that would be a great surprise to South Carolinians, especially considering what's going on in this country today about government telling people to put needles in their arms. I think we've got the government wanting to put a needle in somebody's arm to take their blood. That's a privacy concern. There's no question that's a search. The same Fourth Amendment applies in felony cases as it does in misdemeanor cases. That's not a valid distinction here.
Let's talk about the South Carolina Constitution a little bit.
Thank you, Your Honor. I think the best way to do that would be with an example. And let's go to exigent circumstances here. The state's position is that exigency existed because of dissipation of blood and the fact that she was taken to the hospital. But the record here, developed by defense counsel, is pretty clear that the trooper could have gotten a warrant. These facts are in the record. There's a magistrate on call 24/7. He had the magistrate's number. I don't think any of these places are very far from each other. The hospital and the detention center are all there.
Well, but it's so clear he didn't think he had to get a warrant because he was relying on the statute.
That's right.
Correct.
He had no clue that he was required to get a warrant, but he was. And so my position is they didn't develop exigent circumstances because they didn't exist. The trooper said it was practicable for him to get a warrant. So that is a place where this court can differ. They can say in the South Carolina Constitution, if the state can get a warrant to draw your blood, to let the state pierce your body with a needle, then they got to get a warrant to do it. The arguments about, well, it's late at night on a weekend, well, that's when all of these accidents occur. That's very predictable. The state can't manufacture an exigency that way.
Well, it makes people busier, so there's less elasticity for the officer to exercise discretion. If you got a busy weekend, you got more and more people working, more and more people hurt, more and more people getting pulled for whatever reason, being called to other disturbances. Why doesn't that? How does your argument ring true on that?
I mean, I think that the state can plan for that. I mean, the opposite of that would mean that a drunk at 10:30 in the morning on a Tuesday, an alcoholic is driving in the morning, gets a neutral and detached magistrate, but someone who may have had an extra beer at dinner on the weekend doesn't. And that's not a constitutional rule that makes any sense. That point about the South Carolina Constitution there, at exigent circumstances, the record here shows that they could have gotten. The trooper said they could have gotten a warrant. I think that's why the state waived it. They waived that, and they waived search incident to arrest below as well. The same waiver argument that they, the same concession that they have below is for exigent circumstances they had for search incident to arrest. The arguments he's making about carving out a categorical rule, there's no need to do that. That would be unprecedented for this court to do that. You can address perhaps some of those concerns he has about the seriousness of the accident. That comes into play in the exigent circumstances exception. There's no need to rewrite the search incident to arrest exception for this case. There's no consent. She didn't give consent. And this number, this .275, it takes it out of the harmless error. The jury needed to be able to evaluate Ms. German and her husband, frankly's testimony without hearing that number because this was the result of an unconstitutional blood draw. Protect the citizens of South Carolina's privacy rights and require a simple rule for the police in these cases. Get a warrant.
Unless an exception exists.
We always will be dealing with exceptions
Such
on
as
case by
implied
case.
consent.
I'm sorry, Your Honor.
Such as implied consent.
Well, here I don't even think we have to get there because she didn't consent at all. To the extent that it existed, she withdrew it.
But when she got in the car and turned the key, is that where implied consent begins, or does it begin at the time of arrest? I mean, it has to begin when she cranks up the car, right?
The theory of implied consent applies to anyone who's driving on the roads, Your Honor.
If we accepted that, though, we would be joining a minority of state court jurisdictions who have said that the implied consent statute, standing alone,
It's not enough.
is not enough, correct?
Well, correct, Your Honor, and especially here with an as-applied challenge where someone has revoked their consent, I don't think you have to.
Did the judge rule whether she revoked her consent?
I think that's in the order, Your Honor, and that the order is in the record. He issued a written order, but I mean, he ruled on the implied consent. He just said the statute was valid.
That it was
he didn't
valid.
really even rule on good faith.
Right, so if he says, if he ruled the statute was valid, I mean, the idea of implied consent, indisputably, even if it's an invalid idea, it includes the idea that consent can be revoked. So it would be necessary, especially under these facts, it would be necessary for the trial court to rule whether the consent was revoked. If he's admitting this evidence under the consent exception to the, if he's not suppressing this evidence under the consent exception, it seems to me he must have ruled that consent was not revoked or withdrawn.
I think the ruling is a legal one, not a factual one on that point, Your Honor. I don't think there was any dispute that she had vociferously withdrawn her consent at the hospital. So to the extent the trial judge makes a ruling on that, that's a ruling of law.
So if he ruled that the consent statute applies as an exception to the warrant requirement and validates the use of this evidence, then he ruled implicitly, if not directly, that she did not withdraw her consent.
I would say that his ruling means that no one can withdraw her consent because of that statute that says in a felony DUI, the blood shall be taken. And that's not this case. She did withdraw her consent. So
But that was the basis of the trial court's ruling, that statute and that statute only.
it's not a very involved analysis there. It's very conclusory.
All right, thank you very much.
Thank you, Your Honor.
You're adjourned.